During the middle of your lawsuit, the opposing attorney is questioning you in a process known as a deposition. In the middle of you being asked questions, your attorney yells out, "Objection!" And now he starts arguing with the defense attorney. And you're sitting there wondering, what do I do? You want to know what you do? Come join me on this walk through the beach as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so let's say you sued your doctor for medical malpractice. You claim that your doctor was careless and caused you significant harm and injury. All right, now, during the course of your lawsuit, the attorney who represents the doctor will have a chance to question you. And that's a simple process known, it's really a question and answer session that's given under oath. And it takes place in our office, in our conference room. Now, you should know something. There's no judge there, and there's no jury there. But there is a court stenographer there to record all of the questions you are being asked and all of the answers that you give. And the answers that you give represent your sworn testimony. All right, so now during the course of questioning, the opposing attorney, the defense lawyer, asks you a question, and all of a sudden you hear, "Objection!" And now you hear the two attorneys start bickering. They start arguing. They start almost yelling at each other. And now, after a few moments, your attorney turns to you and says, "Okay, Mr. Jones, go ahead and answer the question." And you're like, what? What did I just hear? My attorney just made an objection. He didn't like the question. I heard them arguing and bickering over this. And now he tells me to go ahead and answer the question? That makes no sense. I don't get it. What's happening is that your attorney thinks that there's a problem with the question. And there could be many reasons why there's a problem with the question. Maybe it's not phrased correctly. Maybe it asks for some information that clearly is not related to the issues in the case. Maybe it's something that we call palpably improper and totally off the wall. Whatever the reason is, when your attorney yells out the word "objection," now you have to wait and pause. Pause to be told what to do. Do you answer the question or do you not answer the question? The problem is you now have to wait until the attorneys finish their discussion, at which point, in all likelihood, your lawyer is going to turn around and say, "Okay, Mr. Jones, go ahead and answer that question." Now, why would your attorney tell you to do that if he had a problem with the question? I'll tell you why. Because this is the discovery process. During this question and answer session, the defense attorney is able to ask you many, many questions, even though you may think, or your attorney may think, that those questions are not directly related to the claims that you are bringing or to the defenses that are being raised by the opposing attorney. Because this is the discovery process, the defense gets to ask many more questions than they could at the time of trial. So, if your attorney has objected to a particular question, what will happen is that if and when your case does go to trial, and now the opposing lawyer asks you the same exact question, your attorney jumps up and yells out, "Objection, Judge!" And now he gives the judge a specific reason about why he believes that this question is inappropriate. The judge during trial will then have to make a snap decision, an immediate ruling, about whether or not that question is appropriate and whether or not you should be answering that question. Even though the defense lawyer has already asked the question during this pretrial deposition, this pretrial question and answer session, and has already gotten an answer and knows the answer, the jury has never heard this before. So this happens, this question and answer session happens maybe a year and a half before you ever get to trial. But the jury, for the very first time, they know nothing about what happened before. They don't know what your answer is. They don't know why this question may be inappropriate. But at the time of trial, the judge will then make a decision about whether or not you are to answer that question. And if the defense lawyer actually wants to try and read that question and answer that was objected to during your deposition, again, the judge will have to make an immediate ruling about whether or not the defense lawyer can actually read the answer to that question. So why do I share this quick information with you? I share it with you because this comes up in every single pretrial deposition in medical malpractice cases, in accident cases, and in wrongful death cases. What do I do now? I heard my attorney yell out "objection." I heard the two lawyers arguing. Now what do I do? What you do is you wait for instructions from your attorney, and in all likelihood, he's going to turn to you and say, "Go ahead, Mr. Jones, answer the question." You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.